I guess it's timely that this presentation fits at the end of your folks' convention. I spoke to Lynette, and she said a lot of things that were discussed, she saw this, and it's a perfect segue. This is the same presentation that I gave on Big Island this past Saturday, which was in celebration of La Hoi Hoi Ea, okay, in Hilo at the Boys and Girls Club. And it was well received, and right now it's also on Big Island Video News, you know, so people are watching it there as well. But each time I give it, I get a different reaction. So I see the audience. You folks can't see each other, but I can see you. So I can tell who's getting it and who's not getting it. And then I got to figure out how you can get it, right? So why don't we begin? So, converging international law and Hawaiian history, an unexpected reality. You folks know pretty much what I've been saying and what I teach and my research and what I do. But I'm going to zero in and apply a law, international law, to this. Okay, that's where the convergence comes. Now, convergence is two separate paths that cross. And when you have a convergence, it's not necessarily always good, because you might have a rupture. Things might collide. But actually, if it converges and it meets and applies, you have synergy. And then it starts taking off on its own. Okay? A lot of people say, man, this thing has taken off as far as this history. You know, when I got back from the Netherlands back in 2001, I entered the University of Hawaii to get my master's in political science, specializing in international relations. I can tell you that the language back then was not the same as it is now. We've gone leaps and bounds. It's amazing how things have been normalized, right? As opposed to politicized, argumentative. Now it's getting into explanation, understanding, comprehension, terminology, definitions. Well, that fits perfect because that's what we do at the university. We don't teach classes to be political. We teach classes and we get to grade people. You know? So I remember I tell my classes, I've been telling a few classes, if you can show me that Hawaii is a part of the United States, then you get an A and you don't have to take the class the whole semester. Nobody could find that.
I was just going, how many takers?
They can provide arguments, but no, we're talking about information that can be falsified. I'm not into arguing, right? This is water, period. You think it's Coca-Cola, that's your problem. I don't want to get into why you think that's Coca-Cola. What school did you go to? What is your curriculum? What classes did you take? See, then I can understand why you believe that. But by me understanding why you believe it still doesn't change the fact that this is still water. It's not Coca-Cola. Okay? So I had to deal with that a lot. And a lot of people didn't like me. I was like the Grim Reaper. Yeah? I'm a destroyer of paradigms. I don't destroy people, I destroy paradigms. And I get people to think outside of the box, and people get very uncomfortable. Hey, welcome to the club. That's just the way it is, right? It's not argumentative, it's just what is. But I have to find a way to get that through, right? So, as an instructor, as a faculty member at the university, okay, I admit I'm pretty good at it in teaching. Because, you know, after a while you teach so much, you get good at it. If you teach and you're not good, that's a problem. That means you're not learning from your previous classes. You just keep building, right? And that's what teaching is. You never think you know everything. And a lot of it is based on pedagogy. Pedagogy is the way you teach, how you interact with the students, not necessarily the facts. Because anybody can state the facts, but can you explain the facts, right? And that's where theory comes in, theoretical framework. Anybody can see what is facts, right? Everything here on this table, they're just facts. But what gives meaning to these facts, right? So if I come in, I look at this, and I see everybody here. I'm seeing people sitting down in chairs. I see a computer. I see a projector. I see notepads. That could inform me that this is some kind of an educational forum somehow, right? So I'm going to start to use educational theory to help explain this phenomenon. If I don't know what the theory is, and I can come in and say, well, you know, kind of looks like football, then I'm going to start using football theory to apply these facts, which will end up not making any sense. And instead of being argumentative, and when you get argumentative, that is a sign that you may not have the right theory. because you're still arguing, you're frustrated. When you have the right theory, it makes sense. You can start to predict what's going to happen, right? That's the appropriate theoretical framework. So you might say, we've been playing football with the United States, but using baseball theory. Colonialism, right? Indigenous rights. And I'm not attacking these terms. I'm just clarifying what the terms are. That's baseball, right? We're playing football. If we're playing baseball, we were colonized, we use those words. We use those terms. We use that framework, no problem. But you don't apply that to a situation that it doesn't fit. But once you start to apply it, see, that's when you're going to have the convergence. See, and now you're going to have synergy. And man, going back from 2001 to now, wow. I mean, this is wow, right there. That is wow. I was completely blown away with that.
Yay, Chris.
You know? They basically came out, and I heard you folks talked about this, but they passed a proposal that the NEA will publish an article that documents the illegal overthrow of the Hawaiian monarchy in 1893, the prolonged illegal occupation of the United States in the Hawaiian Kingdom, and the harmful effects that this occupation has had on the Hawaiian people and resources of the land. The entire NEA convention passed it. It wasn't just HSTA pushing it. It passed. And they got that proposal beforehand. That's how it's supposed to work. You don't get it, right? Oh, let's take a look at it. You're going to take forever going over it. You got to look into it. So obviously, the other affiliate unions of the National Education Union did their homework. And that's good. So what this shows is it's not political, it's educational, and that's what I've always promoted. And this is at the, high school level and intermediate and elementary, right? So that's heavy. And this person right here, Amy Peruso, is a good friend of mine. She actually has her master's in political science. We all went to school together. And she's very good friends with Umi Perkins, who is the Hawaiian history teacher, honors history at Kamehameha Schools, who are using my book, which is my doctoral dissertation, Ua Maukea, as the new history book. I'm not pushing myself, I'm just pushing the right information, right? And it had to be vetted as well. I didn't push it on them. I got word they purchased 500 copies to use. And I went, really? That was really gratifying to me in that I'm not pushing an agenda. It's just education. And people are taking it on their own. Yeah? They're maximizing their kuleana. If there's another book that's better than that, by all means, use it. I'm not trying to push Keanu. But I want to push the right information, right? Because I'm invested in this. And I'm going to hold people accountable. You say this, I say, excuse me, that's not correct. And I can back that up. Nothing personal, just business, right? But because this is about our country, we've got to be careful what we say. We have to realize that something affected us in not knowing this. And we have to keep that in mind. And we cannot keep going back to what we think when we can assume what we thought is probably wrong. We have to reevaluate what we thought. So you always, before you step forward, you got to step back. Okay, check this place out. Am I right? Am I on the right course? Okay, then move ahead. It's a tough process. Over 124 years of brainwashing. It affected us. We are the evidence of it. So we're not wrong. We're just temporarily off track. Right? Everybody get back on track. Because we're talking about a country. Now what I want to jump off of is the prolonged illegal occupation of the United States. They're not saying let's look into whether or not Hawaii is occupied. They're publishing an article documenting the illegal occupation. Okay, that's different. Documenting it. We have a lot of information that we're probably going to be able to cite. We've got published articles, a lot of research that has come out from the university. But that idea of occupation, you can only speak to occupation if you're at war. That's how it works. You can't be otherwise. You have to be at war within international law. That's how it works. So let's get to the theory of international law, and that's what we're going to get into. Yeah? So, Judge Greenwood, he's currently a judge on the International Court of Justice. He stated in an article on humanitarian law, traditional international law was based upon a rigid distinction between the state of peace and the state of war. Countries were either in a state of peace or a state of war. There was no middle ground. Okay? So you always strive to be at peace, but countries could go to war because at the international level, war is looked at as a form of dispute resolution. But it has to be a just war, right? Today they refer to an unjust war as a war of aggression. That's a war crime, okay? But you also had that back then. And there are certain frameworks of international law that will determine whether or not an action taken by a state is unjust. And this framework is called jus ad bellum. That's a term that they use. Justification of war. And if it's not justified, it's illegal. That's how they viewed it. But once you're at war, now international law regulates it, whether it's just or unjust. But they start off, whether it's just or unjust, through what is called jus ad bellum. Then you move into the rules of war called jus in bellum. Okay? These are the two different frameworks within international law and a state of war. Okay? You guys following me? Okay. I have an article on this that's going to be published in the Hawaiian Journal of Law and Politics, and you can actually access it. I'll share where that is on my website at the University of Hawaii, which gets into the details of all of this, you know, where it's coming from, the citations and everything. Okay. Now, important to know about war. War is dispute resolution, right? Did you know Hawaii's recognition of its neutrality, the provisions of neutrality in Hawaiian treaties? That neutrality does not kick in until there's a state of war with other states. Not with the Hawaiian Kingdom, but with other states. Because the rules of war replaces the laws of international law during peace. It replaces it. And that has come to be known today as international humanitarian law, okay? Which in the 19th century was recognized as customary international law. And then in 1899, at the Hague Convention, it was codified. Codification is not creation of new law. It's codifying what already existed. That's how international law works, because there's no international body, right, called the legislature that passes laws. Okay? This is amongst countries called custom. Then moving into codification, which then followed up in 1907 Hague Convention and then 1949 Geneva Conventions. Today we call that humanitarian law. But what's more important, those rules in the humanitarian law applied in 1893. They did. Okay? And there's also a provision in the Hague Convention of 1899 called the Martens Clause. This is where they knew what that meant. The Martens Clause, he was a delegate, and he said, whatever we do not codify, this clause will say customary international practice still applies. You guys caught that? That proves this is codification, not creation of new law. And if they weren't able to codify it, does it dismiss what is already recognized as customary? That's known as the Martens Clause. Give you an example. The Martens Clause. Here they were going to prosecute after World War I. World War I took place from 1914 to 1918. Okay? They're going to prosecute Romanians, Germans, and others for war crimes, right? Because in 1919, a year after the war ended, you had the Allied countries came together, they put together a committee to codify war crimes, that they're going to begin prosecution, including the Kaiser, right? That was the plan to prosecute the Kaiser, as well as government officials and military. And one of the crimes was denationalization. They came up with the word in 1919. And then they used these war crimes to prosecute individuals who committed the crime between 1914 and 1918. What's the problem right here? Just strictly from a chronological standpoint. War crimes were created in 1919, but they're prosecuting people for committing them before 1919. That's called ex post facto. That's retroactive law. Law doesn't work that way. So they couldn't have done that, right?
Oh, they couldn't.
No, guess what they did? You know what they invoked? The Martens Clause. They said that these were already war crimes during World War I, even though they codified it in 1919. That's another prime example of how you can get prosecuted for war crimes, even though the war crime wasn't codified until 1 year after the war. That's how they prosecuted. So does that make sense? This is the theory, right, of jus in bello. Okay. Okay. See, I'm very much into comprehension and not just memorizing, right? Because anybody can read. That doesn't mean they can comprehend what they're reading. We see it all the time at the university. You can read something over and over. If you don't understand the terminology and theory, you're not going to get it. Your comprehension is very low. So what we do in class is we try to expound on the comprehension by speaking to definitions, terminology, applications. You know, you just don't talk about something in a vacuum, which is an empty vessel, right? You fill it with precedence, with understanding. And that's how I teach, and that's how I'm presenting, and I've always done it, to draw from information that helps explain it, so nobody can say, oh, Keanu said this. I'm just speaking to it. This has been around before me. I was born in 1964. 1899, 1893, way before me. So again, this is just explaining why war is regulated by international law. So because there was no forum to resolve disputes, international law viewed war as legal, but it had to be justified. That's the key, justified, right? Because they're going to serve as judge, jury, and execution. That's how it works. There was no tribunal to go to resolve your disputes in the 19th century. In order for war to be legal, okay, again, justified, use ad bellum. And what's more important, international law regulates war. So what we're talking about is what our kupuna knew back then. Joseph Navahi, as the Minister of Foreign Affairs under Lili Bukalani, knew this. But he also knew domestic law. Hawaiian Kingdom law did not apply at this level when he's the Minister of Foreign Affairs for that short stint of time, right? And they knew what was going on. Now, war, right? War. There are 4 stages in war, okay, in international law. First stage, act of war. Whenever you have a statement made by a head of state, not an employee of the government, but the head of that government, of countries, what they say can trigger international law, right? That's why countries are very careful what they say. No comment, still looking into it. One of the big trigger words that moves a state of peace into a state of war is act of war. That term, act of war. In fact, Dick Cheney is trying to get Trump to declare act of war so they can go after Russia under rules of war. Right now, it's still a state of peace with agitation. And Cheney is trying to push it. Say act of war, right? Second, during second stage, surrender. Okay. All the surrender does is cease physical hostilities. It does not transform the situation back to a state of peace. It just ends hostilities. And then it's normally followed by belligerent occupation in order to implement the treaty, right? You just don't sign it and then it just happens on its own. It comes into execution. It has to be carried out, and that takes place during belligerent occupation. Now, occupation throws off the idea in international law during a state of peace called effectiveness. The cornerstone of sovereignty is being in effective control of territory. So you can exercise your laws. Your police can arrest people. Courts can prosecute, convict, and sentence. Okay? That's effectiveness, but that's legal effectiveness. Effectiveness is the cornerstone of sovereignty, right? But during occupation, that's flipped on its head. Because the government of the other side is overthrown, signing a treaty of surrender. So obviously, that other entity cannot be effective, right? If they sign the treaty of surrender, that renders them ineffective and places effectiveness in the occupier. Now, Article 42 of the Hague Convention, which was customary international law in 1893, Article 42 says, territory is occupied when it is in effective control. So once an occupier is in effective control, then comes Article 43, that the occupier must administer the laws of the occupied state. Because you cannot administer the laws of the occupied state if you're not in effective control. And you can't be in effective control if you're not the sovereign of that territory unless it's a state of war. Make sense? Okay, so that's important. That's very important. So effective control during occupation, which then springs Article 43 to administer the laws of the occupied state. And then the final stage, Treaty of Peace. That's when the situation is transformed back from state of war to state of peace. Okay, so these 4 stages are there. 3 types of warfare: physical warfare, economic, and psychological. Okay, I'm a retired captain from the Army. Trust me, I know that. But that's what warfare is. The whole point of war is to take down the other side, to control them. to remove their effectiveness so they can sign a treaty of surrender and then implement the treaty of surrender during occupation and the laws of occupation, and ultimately end the occupation with the treaty of peace. Okay. So let's take a look at these 4 stages as it would apply to Japan and the United States war with Japan. So first, 1941, December 7th. State of war is triggered. Japanese attack Pearl Harbor and other military installations, Schofield and Wheeler, okay, and other places. Now, that act of itself is an act of war, but you need one of the countries to say it is an act of war in order to trigger state of war. Because it could be a common misunderstanding. They just attacked something they thought was something, right? Well, on December 7, 1941, President Roosevelt pronounced publicly that the actions taken by the Japanese was in and of itself an act of war. He triggered state of war, December 7th. Now, here's the thing that clarifies. I've heard people say, no, but there was no declaration of war until later. Well, actually, declaration of war passed by Congress, a joint resolution, was passed December 8th, the day after, in Washington, D.C. Okay? Declaration of war. Okay, here's a real test. There's a court case called New York Life Insurance versus Banyan. 1946 goes to a federal court. The family of Banyan, who was killed during Pearl Harbor, the attack, he's a naval officer, there was an exclusion in his life insurance. It did not cover death during war. The family was saying, he didn't die during war because Congress declared war on December 8th, so when Banyan died, that was December 7th. The federal court said, no. President Roosevelt declared act of war that triggered state of war, and the declaration of war was merely incidental. It was not a prerequisite. So Banyan lost the case. They couldn't cash on the life insurance. So that's a good example where the federal courts knew how this worked, right? And that's what we're learning. Okay, so state of war, December 7th, initiated. Second, September 1945, Treaty of Surrender. USS Missouri in Japan, they signed the Treaty of Surrender. That was just ending hostilities. That did not transform the system, the situation into a state of peace. It was then followed by belligerent occupation from 1945 to 1952. Japan was occupied until 1952, carrying out the Treaty of Surrender. General MacArthur was the Governor General that was administering Japanese law in accordance with Article 43 of the Hague Convention, which they had effectiveness under Article 42 as a result of the surrender, right? And then a Treaty of Peace signed in 1951 in San Francisco, but not carried out until 1952. And that is when it was effectively transformed from a state of peace to a state of war. So, yeah, the United States has been at war with Japan from 1941 to 1952. Yes?
Yeah, and we would like to believe that there was a letter sent from Japan to the United States before any war.
International only looks at facts on the ground. An invasion, that's an act of war. If anything, what President Roosevelt did, he just confirmed it. He acknowledged it. And by acknowledging it, he triggered state of war. Now, Italy. Take a look at Italy as an example. 1938, state of war initiated by Mussolini. He's invading, right? State of war with Italy. Second, 1943, Mussolini is captured. The fascist regime falls. And there's a treaty that ends hostilities. And then the successor government joins in with the Allies against Germany, but they're going to start occupying Italy. Started in 1943. Remember, World War II didn't end until 1945. And that occupation continued until 1947, when there was a Treaty of Peace signed. And that's what transformed the situation of Italy to a state of peace when it was initiated into a state of war, 1938. So does this make sense?
Yeah.
So now when you watch movies now, you can kind of see what should come into your mind right now based upon this information with current events. For real. North Korea. North Korea is still in a state of war. They are. They're even saying it on CNN. Because all that was signed in the 1952, I believe, was an armistice treaty that created the 38 parallel. That is still a state of war. That's why South Korea is trying to negotiate or initiate negotiations with the North to bring it to an end. They're not talking about taking over North Korea. They want a treaty of surrender agreed upon. But it's getting more complicated now because of nuclear missile testing and all these other things, right? But can you guys see this in light of North Korea? Yes. Great.
You mentioned a surrender treaty? I thought it was...
No, sorry. Let's see. Catch me right. That's a treaty of peace, not a treaty of surrender. That was signed in the 1950s that ended the hostilities. Exactly. So remember, there's a difference between a treaty of surrender and a treaty of peace. Yeah. Okay. So, if we're going to talk about international law, we've got to make sure that Hawaii fits in that category. You cannot apply these rules of war to a Native American nation that exists within the United States, right? Because the Native American nation is not a subject of international law. The United States is, right? So you have to be an independent state. So, Permanent Court of Arbitration in The Hague acknowledges in its arbitration award that in the 19th century, the Hawaiian Kingdom existed as an independent state, recognized as such by the United States, Great Britain, and various other states. Now, what is important to know, again, is terminology. So let's test you guys. I'm not going to test you, but I am. What does this mean, independent, before state? Can a state be independent? Or can a state not be independent, but still be a state?
Yes.
Like what? Give me an example.
Japan.
Nope. Japan is an independent state and never lost its independence. With the
Alabama.
war. California.
Oh.
California is a state, right? Well, let's go back to ones on the East Coast. Let's use Georgia. So Georgia is a state, right? But it's not independent. Why isn't Georgia independent? Why is it an independent state? What does independent mean?
Means that you're not under federal, you don't have somebody over
Just-
you, you make your own decisions?
So independent means only your laws exist over your territory, independent of other laws that exist over other independent territories. Independence is political, not physical. It's a legal term, right? So that means that only your laws exist over your territory independent of other laws. Now back in the 19th century, Siam, which is Thailand, Ottoman Turks, Persia, they were states, but they weren't independent. Foreign countries did not recognize, in the case of Siam, Thai law. That was equally applied over everyone within its territory. There was an exclusion. If an American is there and gets into trouble, he can only be prosecuted under American law. That's an extraterritorial effect of foreign law in Thailand. Because these countries, like France, Great Britain, United States, did not feel that Thailand could provide protection to their citizens under the rule of law. The same applied to Japan and every place else. Okay? So they weren't recognized, their independence was not recognized. But Hawaii was. What that means is, when it says here that the Hawaiian Kingdom existed as an independent state recognized by the United States, what is that saying right there? That America is recognizing what?
That Hawaii is an independent state.
That only Hawaiian Kingdom law applies over Hawaiian territory.
Right.
That's what that's saying. And when it says, as well as Great Britain recognizes, so that means British recognize only Hawaiian Kingdom law. We're not like Siam, right, in the 19th century. We're not like Japan. We're not like Persia, which is Iran today. And we're not like the Ottoman Turks. So any American or British subject in the Hawaiian Kingdom was subject to Hawaiian Kingdom law. If he gets into trouble, he could not claim protection from their own laws like he could in the case of Japan or Siam or China. And they call that consular jurisdiction. The consulate served as courts to try nationals of their own country. Okay? So that's important because independent states are the only ones that apply to international law. Make sense? Okay. So, independent is also at the cornerstone of occupation. So Article 42, the Hague Convention, territory is considered occupied when it is in effective control. That's so that Article 43 can kick in to administer the laws of the occupied state. The laws of the occupied state is independence. That's why only Hawaiian Kingdom law is here. Therefore, even though the government was overthrown illegally or signed a treaty of surrender, the occupiers still administered the laws of the occupied state. That's because it's still independent. They didn't lose it because the government was overthrown. Yes.
We were privy to hear Lydia Aholo being interviewed by Alan, who wrote the book, The Betrayal of Lady Uokalani. And it was interesting because Lydia, when she was asked, how did the Queen handle the pressure? And she said, oh, we never talked about that. And so she said the Queen referred to what happened as the dethroning. Did that mean anything?
Yeah, it's the executive office. It's not the overthrow of a government. But we're going to get there. I'm going to kind of cover that. But that's a good point, though. Because dethroning is not equivalent to overthrow of a government. Yeah. So in 1893, there were only 44 independent states, which included the Hawaiian Kingdom. 44 total. Okay. In 1945, when the UN was created, there were only 46. It just increased by 2. And then today, there are 193 independent states. Most of these independent states were decolonized and exercised self-determination. So the word self-determination doesn't apply to an existing sovereign state. It only applies to a territorial state that is trying to pursue self-governance. Okay. And we have the Hawaiian Kingdom flag. A lot of confusion here, I've heard. Slowly, things are working out. Sometimes they're still talking about that Rastafarian flag. You know, there's no record in the Hawaiian Kingdom on that flag. In fact, I know the guy who made that flag, and he actually made up the flag. That's not the Hawaiian flag. And I say Hawaiian is a national consciousness, right? Hawaiian. So in 1816 is when Kamehameha orders that flag to be made. And that flag has a Union Jack there. We weren't a British colony. Because under British law, in order to be a British colony, you have to have a Governor General sent there to administer the territory on behalf of the king. So you have Governor Generals in Canada, Australia, New Zealand, and other British colonies. In fact, you still have them in all the British Commonwealths. We didn't have a Governor General here, right? There's no record of a Governor General administering British law as a British colony. Kamehameha was still king. That was the agreement. Actually, Kamehameha joined the British Empire. He was not colonized by the British. He joined the British Empire because he was still in control, right? And in 1843, it was the British that recognized Hawaiian independence. No longer British law would apply, now Hawaiian law. So now we're going back to Hawaiian law. There was a period from 1794 until 1843 we're British. Then we went back being Hawaiian. Okay? But again, independence. So if you notice in the Anglo-French Proclamation, it says Great Britain and France jointly acknowledge the Hawaiian Islands, or the Sandwich Islands, as an independent state. See, you notice the term, because only Hawaiian law applies. And that's how we're able to get into these treaties as a co-equal, a member of the 44 membership of that small little club. Austria-Hungary, Belgium, Bremen, Denmark, France, Germany, Britain, Hamburg, Italy. Oh, did you guys hear this story from your folks' fellow delegate here? About the flag? I mean, about the treaty?
No.
Can I share it, Manu, the short story? Okay. So Manu here, Manuela, she's Italian. Prego, prego. So actually Manu was responsible for getting me to be invited about a year ago to present at universities in Italy. Yeah, all expense paid. Oh, my wife saw that. I'm going. Now we're all over Facebook, visiting all the different places. But while I was there, Manu shared a story with me that is awesome. Because Manu Manu and I met before going to Italy, 3 years before, through Lynette. So Manu was doing her doctoral research on indigenous rights, Native Hawaiians, colonialism. Remember that theory that we all thought we were in? So did she. And Manu worked for the United Nations, permanent form, yeah? Yeah, so she was an employee for the United Nations. And that's what they all talked about, right? Native Hawaiians as indigenous. So when she came, Lynette basically said, the theory has changed. Instead of indigeneity, it's now getting into occupation and state theory.
She didn't say that. She said you would need to talk with Keanu.
Okay, see, I like it better. You know. So, gotta talk to Keanu. So we met for lunch, yeah, up in Nuuanu. And the first thing that I did when I met Manu, because she's from Italy, was to share with her a copy of the Hawaiian-Italian treaty. So I showed her the treaty, and I kind of just, I didn't sarcastically ask, I said something along the lines of, Manu, I said, do indigenous people have treaties of this caliber with your country? Something like that, yeah? I said something along those lines. And she said, no. I said, no. And she started to read. You're reading the Italian part. Yeah. And she's like, wow. I'm just watching her eyes light up. You know, it's like teaching students for, like our students. They light up. They're going, they didn't see this. And then I showed Manu a government registry of where the Hawaiian consulates were. Genoa, Naples, Rome, Torino. And again, the shock, right? And then she came to my class, yeah? But I then, after sharing that with her, I talked about Hawaii being occupied. And we had a really good talk. So Manu went back home, and then 3 years later, I get this email from her saying, just getting you ready, you're gonna get an invitation. I hope you can make it to present about Hawaii's occupation. And so I went to Italy, and I saw Manu, you know, said, hey, it was in Ravenna at the conference. And she says, Keanu, I gotta share with you what happened. She said that when she got home, her whole life went upside down, academic-wise. Yeah, because everything she thought just was being challenged. So Manu was telling me, it took her almost a year. Was it a year you said? A year to digest it, just like, oh. And then she wanted to go find out in the Italian records, the information that I gave her from the Hawaiian records. Yeah. So she found. What is that?
I still had hope that you were wrong.
Exactly. This guy cannot be right. Yeah. I'm so glad you're saying that because I don't want to paraphrase. But that's what happens with students. And you know, our job as faculty is to bring them along. Not, hey, you wrong or you right. You know, just, it's academic, right? So Manu told me that she found out that if there is going to be a Hawaiian treaty, a copy of it, it will be in the Royal Library in Torino. Now, Torino is northern Italy. That used to be the capital of the Kingdom of Italy. After World War II, it moved to Rome, yeah?
Florence and then Rome.
Okay. So the records were still in this Royal Library. So Manu said she went in, and as you walk in, correct me if I'm saying anything off. Okay, I'm just remembering what you said. When you walked in, you were told by the librarian that the treaties on the left side were all either terminated, canceled, or superseded. Yeah, and then on the left side were all the active treaties. Right, and she found the Hawaiian treaty on the left side, and the librarian was saying because Hawaii's the 50th state, Hawaii was annexed. Yeah.
Well, she said that there is no space for Hawaii in that library because it was too exotic. It was just European history.
Oh, okay. So then, Manu was explaining to her, it has to be put on the right side, yeah? Because the kingdom still exists, always occupied. You know? Now this is an Italian talking to an Italian in Italian about something in the Italian library. Nothing in English. There's no Hawaiian. It's just their information. And she gets Manu to write a letter to the director to explain what it is, because she's a doctoral student. And in Europe, doctoral studies are very respected. You know, unlike in America, everybody thinks a PhD is just somebody's opinion. Actually, in Europe, you're held at a standard because of that research that you're supposed to be qualified in, right? So then Manu gets a letter 4 months later, yeah? thanking her for the information, and they went ahead and moved the treaty back to the right side. And I had nothing to do with it other than showing Manu a copy of her treaty with my country. But that's awesome, right? And that's something like the Hawaii State Teachers Association. They're just taking it to the next level and asking the right questions. You may not have all the answers, but you got to keep asking the questions. That's the key. Thank you, Manu. Japan, now this Japanese treaty, the Hawaiian Kingdom, did you know that in 1871 until 1893, January 18th, any Hawaiian subject in trouble in Japan could only be prosecuted under Hawaiian Kingdom law by the Hawaiian consulate in Tokyo. So Hawaii was actually imposing its laws within Japan all those years until January 18th. And that is when Queen Lili Ukalani had her Minister of Foreign Affairs, I believe it was Samuel Parker at that time, dispatch, of course, a letter to the Japanese, to Ambassador Irwin in Tokyo to notify the Japanese government that Hawaii will be rescinding consular jurisdiction and recognizing Japan's full independence. From that point, Hawaiian Kingdom subjects were subject to Japanese law, and were the first power to have done that. 1894, Great Britain followed, and then everyone else. By 1899, Japan's independence was pretty much recognized, and how you know it was recognized? Because Japan was invited to the Hague Conference of 1899 to participate in the codification of the laws of war. That was their entry into the family. So Hawaii had a very unique place. Yeah, you guys with me? Okay.
No, you can.
1893, Hawaii recognized Japan.
Yes, January 18th, the day after, January 17th. Yeah. And it was actually King Kalakaua in 1881 was asked by the Meiji Emperor in a private meeting if Hawaii would be the first power to recognize Japan's full independence, because we were in the 44-member group, and to set the stage for the rest of the powers to follow. And it was Lili Ukalani that followed through. That's heavy. That shows you we're not just an independent state, but we're a player. They're playing at this level. Yeah. So that's the Netherlands. Well, that Dutch treaty also applies to Luxembourg, because Luxembourg was a principality at that time of Denmark. So Luxembourg actually still has a treaty with the Hawaiian Kingdom under that treaty. Portugal, Russia, Samoa, Spain, Switzerland, Sweden, Norway, and the United States. Okay, so these treaties are most favored nation treaties. Okay?
I have a question.
Yes.
Samoa's treaty. Why is there American Samoa and there's the other Samoa?
That came in 1900 when they split. Actually, there was a dispute between the German claim, the British claim, and the American claim to Samoa. They went to arbitration in 1900. England, Great Britain pulled out of interest, and America and Germany split it. And that's when you get West and East. That happened in 1900. Yeah. Now, Hawaii maintained over 90 embassies and consulates throughout the world. Okay, so a legation, term right here, legation, in Washington, D.C., legation is another word for embassy. Also, founder of modern China, Dr. Sun Yat-sen, attended school here in Hawaii. And what's more important is what he stated to a reporter to the, it wasn't called Honolulu Magazine, it was another magazine. But it was Honolulu Magazine is a successor. A reporter in 1910, Dr. Sun stated, "This is my Hawaii. Here I was brought up and educated, and it was here that I came to know what modern civilized governments are like and what they mean." He learned it in the kingdom, and that's what he took back to China for his revolution. Right? He didn't learn that in America, because if he was in America, he'd be subject to the Chinese Exclusion Act, segregation, very bad. He learned civility and how government works here in Hawaii. That's heavy. That's very telling too. Very telling. So now we're going to bring it in. We already established the fact that Hawaii is an independent state, right? And its laws are independent over Hawaiian territory, not like Japan during the 19th century, right? So if you're occupied, then you have to administer the laws of the occupied state, which is that country's independent, its laws. So in March of 1893, President Cleveland initiates an investigation of the overthrow. On December 18th, he reports his findings to Congress. And basically, this is 11 months later. Now when he speaks, America speaks. Not James Blunt, not Secretary of State Gresham, the President of the United States. He's the head of state. So this is what his message is to Congress. It resonates to also the embassies of other foreign diplomats in Washington, D.C. On the 16th day of January, 1893, between 4 and 5 o'clock in the afternoon, a detachment of Marines from the United States steamer Boston with 2 pieces of artillery landed at Honolulu. The men, upwards of 160 in all, were supplied with double cartridge belts filled with ammunition and with haversacks and canteens, and were accompanied by a hospital corps with stretchers and medical supplies. What do you think they're going to do? They're anticipating a fight, right? Now, what is that, though, in international law? How does international law view that? Well, I should hope so. President Cleveland says, this military demonstration upon the soil of Honolulu was of itself an act of war. He nearly said almost what is identical to what President Roosevelt said after the Japanese attack. Act of war. And then he refers to the Queen in this situation, this very precarious situation. On the one hand, the Queen had possession of the palace, of the barracks, and of the police station, and had at her command at least 500 fully armed men and several pieces of artillery. So he's acknowledging we got our side too. And you're going to have a collision, right? Indeed, the whole military force of her kingdom was on her side and at her disposal, while the Committee of Safety, by actual search, had discovered that there were but few arms in Honolulu that were not in service of the government. In this state of things, the Queen could have dealt with these insurgents alone. Her course would have been plain and result unmistakable. Now you notice the word he uses, insurgents. Well, today we say businessmen. Americans. He didn't. There's no mention of that in this message. He calls them insurgents. And when you're an insurgent, you're a traitor. And if you're convicted under Hawaiian law, like in any place, you get executed. But insurgents, so we have to stop calling these people businessmen. You know? It's like everybody's trying to hide away from the real word that is supposed to be used. They're insurgents, period. Not their families, just them. And then he continues, but the United States had allied herself with her enemies. Again, that's a trigger word right there. That means he's acknowledging this is war that has taken place. And had recognized them as the true government of Hawaii and had put her and her adherents in the position of opposition against lawful authority because America is propping them up. See, now it's not an issue of the insurgents, it's the U.S. Marines. And those guys were illegal. They just illegally landed, which is an unjust war. He goes on to say she knew that she could not withstand the power of the United States, but she believed that she might safely trust to its justice. Because remember, unjust war. She's putting everything on the U.S. ambassador. And here's her surrender, a conditional surrender. I, Lili Ukulani, by the grace of God, am under the Constitution. She wasn't above, she was under it. Queen, do hereby solemnly protest against any and all acts done against myself and the constitutional government of the Hawaiian Kingdom. Oh, and by the way, you always hear people using the word Kingdom of Hawaii. Yeah? Use that word. You hear that word, Kingdom of Hawaii. It's not. It's actually Hawaiian Kingdom. You know where Kingdom of Hawaii comes from? 1993 Apology Resolution. That's where it comes from. This is Hawaiian Kingdom. You don't ever see Actually, there was a Kingdom of Hawaii when Kamehameha had that island. Because then you also had the Kingdom of Maui and the Kingdom of Kauai. But they were consolidated under the Kingdom of the Sandwich Islands, which came to be known as the Hawaiian Kingdom. Yeah, so we need to know our evolution of terms. Yeah. Then she says that I yield to the superior force of the United States. She's talking to the U.S. military, not the insurgents. That I yield to the superior force of the United States, whose ambassador, Minister Plenipotentiary John Stevens, has caused United States troops to be landed in Honolulu and declared that he would support the provisional government. See, this is unjust because right now you have an ambassador that just violated the basic norm of international law at that time was the duty of non-intervention. You don't intervene in the political affairs of another country. He did that. Oh, he could be yeah. Well, I don't know, double agent, but she's calling him out. She's saying, America didn't do this, the ambassador did. It's unjust. And here's the clincher. Now, to avoid any collision of armed forces and perhaps the loss of life, in international law, when you use the word armed force, you're referring to troops of a state. That's not insurgents. Insurgents are revolutionaries. They're criminals, right? I do this under protest and imperil by said force, yield my authority until such time as the government of the United States shall, upon the facts being presented to it, undo the action of its representatives, and reinstate me in the authority which I claim as a constitutional sovereign. A lot of people, I hear some people used to say, "I think the Queen just take on the military and take them out." Yeah, to get more military coming. And plus, this whole situation was based upon an ambassador and what he did, not what the United States did. So the Queen was put in a position, she got to play diplomatic because she knows this is war. And she can't allow them to play that card. She got to trump them. And that's what she was doing. The terms and the words was very, very important.
So, how can I put it? She did that because my understanding is we went to war, like you said.
We'll get a treaty of peace where they got Hawaii.
Yeah, so
And they annexed us.
We need treaty of annexation. We're gonna have nothing for us.
Yeah.
Right?
Yeah. But now remember, she knows how government works. You know, she got to play this very, very carefully. This is called crisis mode and crisis management. And they knew what they were doing, right? So what's interesting too as well is, who are these insurgents? Remember, Cleveland already said they're insurgents, but who are they? Well, he told Congress, when our minister recognized the provisional government, the only basis upon which it rested was the fact that they said it exists. They just declared themselves. But remember, they're still insurgents, right? That's what he said. He said they were neither government de facto nor de jure. There's some terminology you got to learn as well now. Remember, use ad bellum, use in bello, de facto, de jure, they're using it. These are international terms. A government de facto is a successful revolution, which is internal. Yeah? An internal revolt, successful, got control of governmental machinery, acquiescence of the people, now they're moving forward as a lawful government. Okay? Now that wouldn't be a state of war in international law, that would be an internal dispute that international law would look at as a, what is called a state of peace. Because there's not a fight between two states. This is a fight between insurgents and the government. These are traitors. Okay. Now if another country gets involved, then you kick it into a state of war, which is what Cleveland said. The landing of the troops was the act of war.
I don't want to interrupt your train of presentation, but would you consider the BNA Constitution a de facto government?
No, because they're not in control of governmental machinery. They're still fighting it, so they're still insurgents. And James Blunt actually tied 1893, these insurgents, to 1887. Yeah, it's in his report. He ties them to it. Yeah, so when people start to say the BNA Constitution is the lawful constitution, that's treason. Don't step into those shoes of those insurgents. Just say, I never know. I didn't know. And government de jure is a lawful government where it has come about through appointment, commissions, elections. It's lawful. He said they were neither. They're insurgents. So the provisional government was created by the U.S. ambassador and served as a puppet regime for the United States. That is clear. Now, the consequence of the act of war. Because remember, the presence of the troops was in and of itself an act of war. That's what he said, right? Now he has the consequence. He addresses the consequence. By an act of war, the government of a friendly and confiding people has been overthrown. He just made a conclusion, which caused the Queen surrender. But that surrender did not change to a state of peace. Still a state of war. What's supposed to follow a state of war? A treaty of surrender?
Belligerent occupation.
Occupation. To administer the laws of the occupied state, because the occupied state has been rendered ineffective. So you cannot expect the Queen to administer Hawaiian Kingdom law. She can't. International law mandates the occupier to do that. Okay? But you need also a treaty of peace to get the Hawaiian Kingdom to administer its own laws. Until there's a treaty of peace, under jus in bello, it is the occupier that administers Hawaiian Kingdom law. not the occupied, because they can't, right? And also under international law, there's also a temporary obedience, not allegiance, but temporary obedience to the occupier in the administration of the laws of the occupied state. So there's a provision of temporary obedience, not allegiance. Allegiance can only be given to a country. And anytime you give allegiance to an occupier, that's a war crime. And we've seen that with the provisional government, oath of allegiance, republic, oath of allegiance, territory of Hawaii, take seat, oath of allegiance. Those are all war crimes under the laws of war. Key is no treaty of peace. No treaty of peace. So on January 17th, the Hawaiian Kingdom came under belligerent occupation. That's how international law sees it. But the problem is the United States did not comply with the law of occupation, and they're trying to paint the image as if Hawaii had an internal revolt and that the provisional government is legal because they changed the name to the Republic. It's all a false narrative in order to conceal the belligerent occupation. Because until you can show me the Treaty of Peace, I'm still in a state of war, and the laws of war apply. So, what's important is the law of belligerent occupation recognizes two legal systems, the occupier and the occupied. Okay? Because what was overthrown in 1893 or taken over was the government, not the country, not the legal order. Right? So, the laws of occupation have the two legal systems that are inherent in the rules. That the occupier administers the laws of the occupied. What laws do they apply? The country's independence, which is their laws. It's all part of laws of war. That's why you cannot unilaterally annex a country during war, because you're supposed to administer the laws of the occupied state, not just take it. That's illegal. That's a war crime. Right? Now, according to Judge Crawford of the International Court of Justice, belligerent occupation does not affect the continuity of the state, even when there's no government claiming to represent it. Because the rules of occupation apply, not what we think. And we've been led to believe a false narrative. So we have no say in international law other than complying. Does that make sense? And a lot of times we don't like to hear that because sometimes we still have this American idea of democratic principles. Everybody has a say. Yeah, during a state of peace in America. Not here during a state of war. But you also have rights to expression under Hawaiian Kingdom law as well, but not during a state of war. So the Hawaiian state, since 1843, Hawaiian government exercising that authority. That government was seized by the United States through its puppet, the provisional government. The state still exists. So in looking at this big picture, if anything we can glean from this, not the government. So stop chasing forming a government, right? Like in the sovereignty movement. Everybody's trying to explain who can best create a government. You notice nothing worked. Yeah, everybody's still arguing because that's an American concept during a state of peace. This is occupation. So the key in occupation, which is its foundation, is the state, not the government. The government comes after. And if the government comes after, it's still within the rules of the law of occupation. Make sense? Okay. So the only thing that changed back in 1893, we have to understand, is the name. The governmental infrastructure of the Hawaiian Kingdom was intact. All that was changed was the Queen and her cabinet. The Queen and 4 ministers and Marshal Charles Wilson. So a total of 6 people were removed, replaced by an executive and advisory council made up of 18 insurgents led by Sanford Dole, so-called Vice President Samuel Damon, but again, insurgents. And then they forced everyone in government already existing to sign oaths of allegiance. That's a war crime right there, but also they're insurgents doing that. So it has no legal effect. Because President Cleveland said, not Dr. Sy, he said they're insurgents. They're neither de facto nor de jure. So they just changed allegiance. The entire infrastructure of the Hawaiian Kingdom, its courts, all the circuit courts, all the district courts, the Attorney General, the tax office, the Board of Education, all it did was just sign oaths of allegiance. Yeah? So this is called hijacking. hijacking an already existing infrastructure. It's called a regime change, we call it in political science. Not an overthrow of a government, which is going to the dethroning. Exactly. Right, Andy. So the name changed merely from the provisional government to the republic, to the territory, to the state of Hawaii. The governmental infrastructure you see here today is the kingdom. Yeah. Same. It's got name change. Department of Land and Natural Resources is actually the Interior Department. The Bureau of Conveyance is still there. The Sheriff's Department, Police Department, Fire Department, all from Kingdom era. Did you know actually all the public schools, Kingdom era, 1830s. Yeah. Did you know even majority of the ILH schools, Kingdom era? Kamehameha is actually one of the youngest. Kamehameha Schools was established 1887. St. Louis, 1846. Punahou, Oahu College, 1836 or something, 1830s. Iolani, 1870s. St. Andrew's Priory, 1870s. Midpack Institute, that's actually Kauai House Seminary. Yeah, it's like we're waking up to this reality. Oh my God, everything's still here.
The Capitol building, would you consider that Hawaiian Kingdom, or what would you consider?
Well, they just created something to move from the palace, because that's where they used to be. Then they created that capital to go into. They actually took over the palace and held the legislature there until 1978. Yeah, 78. Does anyone remember? Yeah. That's when they moved to the new so-called new capital. Yeah. And a person, a good friend of mine, Walter Riddy, I remember he was asked a question by my cousin Cody. He said, when he asked about the palace, or she asked about the palace, what do you think about the palace? Because to my cousin in this interview, she's saying, didn't you realize that it's not the state when you see the palace? And he said, I didn't see anything. Because you know why? That was the territorial government. That's what a governor was. So all they did was hijack a plane. I call it Hawaiian Airlines. They just changed the pilot, locked the door, you can't get them, released sleeping gas in the cabin, everybody fell asleep, being told they're Americans through Americanization. Everybody starts to believe it. And then you got the plane painted red, white, and blue, but after 124 years, starting to chip. People started to realize there's something wrong with this. That's what we're uncovering right now. So this paradigm, this shift is taking place.
Trivia note that the sand that they built the capital with, do you know where it came from?
No.
The island of Molokai. And the Western state, we don't have any mineral rights and so on, but now the issue of the sand mining from Maui. And then I was told, well, the sand to build Ala Moana, that complex there, the sand came from another trip, Waimea. Waimea, the rock was used to be, the sand went all the way out, so it was enclosed by sand. Now you jump out into the water. I said, I didn't know that. That's interesting. And so they're using our resource. I don't know.
Well, actually, our own people were using it because we're all led to believe that this was America. So my uncle was part of the building of the Reef Runway. He never know that Hawaii's occupied, because we still got to get to the point of why is it that we think the way we think, and this is so drastic. So basically, I want to conclude this slide with the state of Hawaii governmental infrastructure is the Hawaiian Kingdom. You're looking at it. It is. There's no way around it. Just name change. So stages within a state of war regarding the Hawaiian Kingdom, the 4 stages. First stage, January 16, 1893, U.S. troops landed. Remember President Cleveland? That in and of itself was an act of war. So he triggered state of war. So when a foreigner, when somebody from Italy, let's say a law professor or a government official, when they read President Cleveland's message, that would jump right at them. Act of war. Whoa, the president said that, not some guy off the street. They will know state of war was initiated. Second, January 17th, the day after, surrender. We got a conditional surrender from the Queen. Conditional surrender. From 1893 to 2017, belligerent occupation. That's how the law sees it. Now, has the United States complied with the law of occupation? No, because that's why we're in the position we're in now. Right? Because there's no government there. then the United States is responsible for administering Hawaiian law. What they did was they propped up their surrogate and make it look as if it's not an occupation.
Can we bring that government back?
But we're going to get there. And so we're just explaining how international law looks at this. Remember, converging international law with Hawaiian history, a new reality. The bottom line is we have no treaty of peace, period. We're like Korea. You can go to Seoul, shop. It doesn't look like a state of war, right? Just like how you can go Ala Moana, go shop. That doesn't look like we're in a state of war. We actually are. But ours was more deceitful because it was hidden. So the state of war still ensues today. Why is it that we didn't know all of this? 1906, Program for Patriotic Exercises used in the public schools. Right here, adopted by the Department of Public Instruction. So now they're using our agencies to change the minds of the children, to conceal. The theme of the program was to indoctrinate the children of Hawaii to be American and to speak English. The purpose of this is to conceal the occupation. That's what this is. It is not about bashing natives. It's not a native issue. This is a national issue. Because even if a Chinese child is speaking Hawaiian, which is the national language, they get discipline as well. This is not native-oriented, like how we've been painting the picture in the sovereignty movement. This is not the sovereignty movement, and I am not part of the sovereignty movement. I'm not chasing sovereignty. Yeah? The people in the sovereignty movement have been operating on the wrong premise. They've been operating that we're part of the United States, they don't like it, and they want to break away, and everybody has a way to break away. So you have an independence movement, which is political aspiration, not operating on a reality. Because independence is in the state, not in the people. Make sense?
Yeah.
Okay. So, 1907, Harper's Weekly magazine does a story on the brainwashing called Americanization. So they visit Kaiulani Public School, Ka'ahumanu Public School, and Honolulu High School before the name was changed to William McKinley High School. Another part of brainwashing. So, at the command of the principal, 614 students, grades 1 through 8 at Kaiulani Public School stand at attention and they salute like this. That's the old civil salute until Hitler hijacked it. Then America went like this. Yeah, I'm serious. Before it was that's the civil salute from Rome, right? For civilians, military like this, right? So they went like this, saluting. So at the command of the principal, they all yell in unison. We give our heads and our hearts to God and our country, one language, one flag. This scene shows the salute to the American flag, which flies in the grounds of the Kaiulani Public School, which has many Japanese pupils. The drill is constantly held as a means of inculcating patriotism in the hearts of the children. Inculcate, brainwash through repetition. That's the definition of inculcate. Brainwash.
Why do you think they use the term many Japanese?
The whole justification to take over Hawaii because of a Japanese attack on the west coast of the United States and a German attack on the east coast of the United States. Captain Alfred Mahan was the architect of this narrative. Yeah. So, can you guys understand why we don't know what we know today?
Yes.
Because that
Yeah?
That 1907 picture is my tutu's generation.
Yeah.
By the time I got to my dad at St. Louis, it's already institutionalized. He doesn't know nothing. By the time I got to me at commitment schools, I was blank. Out of sight, out of mind. I wasn't angry, I just didn't know. And I'm going to a military college, get my commission as a second lieutenant, retired as a captain. And then I woke up, right? So it's important to know it's okay for not knowing. But it is not important it's not okay when you know when you know it and you're still pushing it. See, then it's called collaboration. Now we're talking war. You a collaborator? Remember what happened during World War II? The French? Yeah. So during this time, I would recommend people step back. Be careful what you say. Now, with this background, there's a sign, this symbol that is all over, that with this knowledge, it now looks like a sign of occupation. But yet we've taken it for granted, right? So remember that Hawaiian flag? That's a national flag, right? That's not the state of Hawaii flag. That came from 1845, which was revised from the 1816 formed. And that American flag, that's a national flag too, right? So, wasn't the Hawaiian Kingdom a member of the family of nations of those 44 countries in 1893? Wasn't the United States a member of that 44 member nation family? Yeah. So this is the sign of occupation right there. Now it's a different person. Now I'm going, whoa. See, that's different if that was a 50th state. That's not even the 50th state's flag. That's from the Kingdom of Maryland. Remember, they just changed the names. Brainwash everybody to believe it. What I found interesting, every time you see Native Hawaiians, they carry that flag. So some guys coming from America, a little confused, look, is that a state flag? Oh, that's a Hawaiian flag. Well, it's not the native flag, but it's kind of interesting that the state flag is used by Native Hawaiians as the Hawaiian Kingdom flag, which is pretty cool. It's part of the awakening. And then when somebody started using the Rastafarian flag and say, well, that's the Kanaka Maoli flag, okay, now you're just making stuff up. Because there's no historical evidence for that. And if we're basing our stuff on historical evidence to hold the United States accountable, I think we should start holding each other accountable. Right? If they can show that that was from the Kingdom Era, hey, right on. Until then, stop. And stop giving a story. But now it's kind of hard because it's on hats, t-shirts. See, now it's a commodity. Ooh, that's like creating Frankenstein. It's already marching on its own. But the key is, it's not the Hawaiian flag. That's the national ensign. Period. Right.
You know what's interesting, when we went to DC and we took our put up the Ku'e petition names, we were on the National Mall, and I found that Americans just stayed away. However, the European people came up and asked us, what is the Union Jack doing?
Oh, everybody catches the Union Jack.
So, yeah.
And then some Hawaiians, you know, because that's what prompted the Rastafarian flag. Oh, we don't want that flag because it looks like we're a British colony. That's not what that represents. Hawaii was a protectorate. Come in and join the British Empire. And then Great Britain recognized our independence. So we did have a sovereignty movement in 1843.
Keanu, what was, you know, when Korea came back after Hugo, and when they went into New York, and it was coming to Lady Liberty, and that was a beautiful picture, but one thing that catch my eye.
The American
flag.
flag. All right. No, that's the law of the sea. Because that's the nationality of the ship that actually protects it. So it's not like there's a political protest you gotta have. The flag that you have protects the ship. And that's why the Hawaiian Kingdom flag, that flag used to fly over Hawaii. So if Hokulea was flying the Hawaiian flag, the problem is the world they don't know the Hawaiian Kingdom still exists. So why would you do that? Until then, you gotta follow maritime laws. So even a British ship coming in, let's say a yacht, they're gonna fly the British flag. Yeah.
Excuse me, I was in the impression that the crew did only the Hawaiian flag flew. Only when they got into that harbor did they put the American flag up. But when they hit South Africa and only the Hawaiian flag was flying.
I don't want to try to spread that because it's not confirmed, but I can tell you the law of the sea actually requires, that's the nationality of the flag. That's like, it protects that ship. So they weren't doing this because of what you guys are just learning now. And we gotta be careful. Yeah, we gotta be careful and not make it political. Yeah, I don't want to say they did something when I don't know what they did because it has ramifications. See, I'm not going to set anybody up. Yes.
I think one of the things that most people are aware of is the dimension that the state used on the flag is a Hawaiian.
Yeah, a little longer. Yeah.
So it's double the length of the line.
Yeah.
Compared to the state flag is like 3 by 1.
Yeah.
So it's too short to be the Hawaiian Kingdom flag.
Yeah.
But that's what's available.
Well, the design. Yeah. I mean, when I get into particulars, because today at the UN, they all fly the same size dimensions. So you may have a longer dimension, but if you go to the international level and you go to the UN, you have all the flag, the poles, yeah?
Yep.
They're all the same dimension.
Yeah.
So the key here is the design of the flag is most important. That's Hawaiian Kingdom flag. And the so-called provisional government and republic, they never changed it. Because they had to make like, we succeeded in our takeover, we're just carrying on. That's how they played it. Yeah. But good point. Yeah. Baron Chin keeps bringing that up. I say, point well taken. you flag man, you. Hi Hawaii. For him, Kuhai Hawaii, which is my flag too, you know, I love it. So, given all of this, what do you do, right? Because this looks pretty complicated. Yeah? But actually, if you understand international law, it's pretty straightforward. So number one, what is the key to the law of occupation? The existence of what? The existence of something is the key to the law of occupation. Independence, right? Because that's the law of the occupied state. So you can only speak to independence if you are a state, right? Because not all states are independent. So like Georgia is a state, but it's not independent. Because in Georgia, you got more than one law. You got federal law and Georgia law. But from 1773 to 1789, for 6 years, after King George III recognized the former 13 colonies as independent states, he did, they were independent, in a loose union called a confederation. Did you know only Georgia law applied over Georgia territory? Because Georgia was independent. In 1789, these 13 independent states gave up their independence into a national government called a federal government. Thus, they have what is called residual sovereignty. And they were then, at that point, called a state, not an independent state. The independent state was the United States of America, which they created in 1789. Make sense? So you see the word independence? And I read your folks' you showed me the
Objective.
the objective.
Right, the objective.
Yeah. So crucial because it is acknowledging the continuity of the independence. Because that's in line with international law. Now back in 1893, that independence was being threatened, right? What was threatening Hawaiian independence in 1893 to 1898? That was why it was in the Constitution of the Hawaiian Patriotic League. What was threatening the independence? Nope, not insurgent. Huh? More so. Annexation is an action. See, again, another word. Annexation is a consequence of cession. Annex is extension. So when you go to a building, Annex 1, you go to the prison, Annex 2, right? You can only be an annex if you were ceded. So cession is first, annexation is a consequence. So cession, right? What was the threat to Hawaiian independence, Hawaii's autonomy, its independence and autonomy?
Active war.
No. How can you get somebody's independence?
Surrender.
No. Remember, treaty of surrender ends hostilities. You need a treaty of peace. Like the Guadalupe Hidalgo, the 1848 Mexican-American War. That's when all the lands north of the Rio Grande were transferred to the United States under the Treaty of Peace. Right? Make sense? So, what we have today is we still have the independence, right? And that the United States is supposed to have administered Hawaiian Kingdom law, which we know they didn't. That's not an argument, they didn't, which is why we're in the position we are today. So, if they acknowledge to overthrow the government under an unjust war, then we really had no government here since 1893. Republic of Hawaii was not a government, those were insurgents. Remember? Cleveland said it. Territory of Hawaii, name change, Republic. Congress said it, but Congress can't have any effect beyond its borders. 1959 statehood act, changed the name from the territory to the state. So actually there has been no lawful government in Hawaii, but yet we have a governmental infrastructure here that has been here since 1893. Just somebody hijacked it. And now we have our own family members in it. And I work for it. I'm a faculty member in this illegal state of Hawaii. And I have pay coming from pillaging, which I contributed. See, those terms now all come into play because a state cannot tax. A state of Hawaii cannot tax if it's not a real government. See, that's what's happening here with this information. You see the convergence? So, since elections cannot take place under international law, so let me ask you, why can't elections take place during international law? Because that's a rule. You can't have elections during occupation. We're just talking procedure. Well, somebody's in effective control.
The occupier, though.
But who actually does election? Who registers voters? Okay, let's use not Hawaii as an example. Let's use state of California, which uses the same rules as a state of Hawaii. Who registers voters in California?
Government.
Exactly, executive branch, which means a government, right? Who creates and establishes the voting polls? Government. Who counts the ballots? So you need a government before you can have elections, right? So you can't have elections to create a government because you need a government to have elections. What came first, the chicken or the egg? But do you have elections during occupation? Because the lawful government has been overthrown, which is why you're occupied. And the occupier cannot have elections because they're not the real government of the country.
The will of the people not counted out.
Nope, will of the people have nothing to do with anything in international law and the law of occupation. The will of the people has everything to do with the domestic laws of a particular country, including the Hawaiian Kingdom, because its will is expressed through election. Our people were electing officials in the kingdom. There is no doubt. But you can't do that during occupations because occupation prevents that. Does that make sense?
So how do we get out of this dilemma?
Oh no, but you're starting to see the dilemma, right? Okay, but there are rules that got to be followed, but you have to understand what are the basic premise before you start saying, I'm going to come up with a plan, right? So right off the bat, you can't create a government through elections. And what represents a state in international law is a government.
Or the people, where do people come
People is an American democratic principle.
So,
And you know when they say the people are the sovereign? No, they're not. They're not. Actually, the sovereignty of the states, of the former 13, or the 13 original states, you know where the sovereignty came from? Do you think it came from the people? It came from King George III, the Treaty of Paris, transferring his authority, his sovereignty, into these 13 independent states who are represented by the people through an electoral process. The electoral process is not sovereignty. Sovereignty belongs to the country. The question is who can exercise that sovereignty. You can have a democratic system, you can have a republic system, you can have a monarchical system, you can have a tyrant system. Whatever government you have, what you're exercising is the sovereignty of the state, not the sovereignty of the people. What you're exercising from the people is their will. That's different. That's political. And it's still real. But it fits within this greater scheme. Yes, I do.
We have the general group that proclaims themselves the government.
Yeah.
So one of the government all the elections.
The Grand Poobah and the Water Buffalo Lodge can do whatever they want.
Some like Henry Rowe, for example, claims he's been represented at international.
You know, I
don't know.
see, I can claim to be the kingdom of Timbuktu, and everybody here votes for me. That still doesn't make it right, or not right, legal. Now, I don't like to entertain the sovereignty movement as if they're trying to be a government, because once you say that, now you're venturing into an arena that you got to be careful. See, that's the problem. You got to be careful what you say, because whatever you say could be used against you, even under Hawaiian law, even under the laws of occupation. So it's not a matter of trying things, because what you may try might become your end. So I'm very careful on what you say. I just shrug it off like, oh, well, it's just an organization of Hawaiians getting together and they voted. I'm not calling it a government, because number one, you can't vote during occupation. That's just the way the rules work.
Okay, I'm very familiar with the Kalahu did Iunani. Okay, when we, and I was there when we gathered at the Pukaokalani Church in Hilo. And it was just people that got gathered. We, out of our own pocket, we were there. And we went through, anyway, so that the way it was set up, was the people came to some whatever. Anyway, what happened was we registered over 10,000 people, and with the League of Women Voters handling the statistics, I know that I was on the how to disperse or create the precincts, okay? And we were told by the League of Women Voters that Illinois' office was on it, because we're very close.
Okay, so Auntie, we got to cut things to where it's supposed to be. All of that doesn't apply to this information. Whether it's Kalahui, Nation of Hawaii,
So how do we get,
That's what I want to get to. But we got to be careful. We got to stop pulling in the oil with the water. What I'm trying to do is separate them, because the only way oil and water can work is like Caesar salad. You got to keep shaking it. And then when you let it sit, it separates. And then when you want more confusion, shake it again. What I'm trying to say is, take the water out of the bottle.
tired of shaking?
Tired of shaking. Tired of swishing. Okay, there's a swishing thing here now. Okay, so there's a olelo no el that Lynette knows. And it's olelo no el that I share with my students and I share with in presentations. It refers to the kahuivai, the water gourd. Okay, so the water gourd represents the person, and water in the gourd represents knowledge. The gourd with a little bit of water makes the most noise when you shake it. You guys got that one?
Yeah.
Swishing. We have to stop swishing. We have to start filling the gourd. See, we have to do that. We got to stop saying what we used to say because of how big this is. And this is not semantics. This is not, I have an opinion. You have an opinion, but it's really worth nothing if it's not in this context, because we're dealing with occupation. People are waking up to the reality of war crimes. We're talking about accountability. See, the domino effect is started. And that's why we have to be careful. So it's not trying to take what we've done in the past and make it right when it has nothing to do with this. We are actually going back to how Navahi would see it, how Kaulia would see it, not how George Helm would see it, not how Billy Richards would see it, because they didn't know this, because I didn't know it back then. But everybody had a kernel of truth. We didn't have the cob with all the kernels. We're now starting to see all the kernels. Everybody, oh, this is a bigger corn than I thought. Right? So my recommendation, stop talking about these things. Let's move on. Don't forget it. That's part of our history, but it's part of the brainwashing. Since 1907, formal brainwashing, inculcation. Yeah? And I always got to check myself too. What am I saying? When I say Native Hawaiian, should I say Aboriginal Hawaiian? Okay, Aboriginal Hawaiian. What is a Native Hawaiian? Natural born. Okay, see, I'm still checking myself on these terms, right? Okay, so I'm just saying it's not just you folks that got to be careful. I got to be careful as well, because I'm in the public and I get filmed like this, and it could be used against me 20 years from now. Because there's no statute of limitation for treason. Yeah, no, I'm serious. That's how it works. We're playing with a very serious issue here.
We can bring up Alexander Paul, we can get them.
I'm not into chasing people right now. I'm just getting into understanding the situation. Right? I'm not into casting blame. Because the problem is I got my cousin who's a cop, my auntie works over here. It's not the insurgents that used to be there. That's my cousin. Ooh. I was in the gut. Ooh. Was I committing treason by firing 105 howitzers at Pokuloa at Pu'ai? You know, that all comes into play. See, now I'm in it. So we're all caught in this, and I think we don't have to cast blame. Yeah? You point your finger to somebody, right? You got 3 fingers pointing back at you. Put the hand down. What do you know? Where are you coming from? And that's why our job here as a people is a lot harder than other places, because we are still recovering memory that we never had. If this was still fresh in our minds, we should follow these rules very easily. But now we don't even know who's this and what's that and where's that. So let's just back up, right? Okay, so since elections cannot take place, but we have to create a government to represent the Hawaiian state, because otherwise the Hawaiian state is silent, which it has been, right? Since 1893, it was silent. Steps were taken in line with how governments in exile were created during World War II. Now, governments in exile, okay, operated on necessity. That's how you get around no elections. So in 1995, a legitimate provisional government. Now you notice I said legitimate. Was there an illegitimate provisional government?
No.
1893. Neither de facto nor de jure. Remember Cleveland? That was a provisional government. Were those guys elected?
No.
No. They were basing it on necessity. That's why they blamed the Queen for everything. They had to paint the image that the Queen was a tyrant. Natives cannot rule. We have to take over.
Yeah.
See, that's the justification which provides necessity to claim to be a provisional government. Because provisional governments are legal in extraordinary situations. Okay? And at the core is necessity. That's actually a legal doctrine. It's recognized in international law. Okay? So, you have what is called acting or provisional. They're interchangeable, right? Temporary. So I'm faced with this information back then. So somebody just realizing this now. Imagine I realized this back in 1995. Actually 94 when I retired. That's when I went from the OMG to the WTF.
Before that was it.
Before that, I was just firing rounds. Went to Japan, Korea. Yeah, I loved it. And I went, ooh, I think I'm in the wrong army. Whoa, whoa, you know, it's like, whoa, whoa. And then I look at everybody. They all think I'm crazy. Oh, yeah, I knew this a long time, you know. Lynette knows. She knew me back then, 95. So we decided to follow precedents. And we're going to create a provisional government that is not established by elections, because you can't have elections during occupation. So how did other governments get created during occupation? And that's why we went to the World War II and said, hey, government's in exile. So in Belgium, its government was captured. The German invasion, they actually captured King Leopold, the king. Citizens fled. In London, they formed a provisional government that represented the Belgian state, not the people. There was no will from the people, right? So they created a government in exile. And its job was to ensure that the protection of the state is complied with under international law, which would then apply to the people within the occupied state. Make sense? So there's a difference between representing the state and representing the people through the will of the people. Right? So we just follow the logic of what they did in 1940s.
Is there a certain minimum number of people that constitute a legitimate provisional government?
The only requirement is, and actually this came up because of Czechoslovakia in London. Czechoslovakia did something. Czechoslovakia, citizens fled, and they had a national convention in London where they elected a provisional government. The Allied countries did not recognize that. Here's the reason. There was no provision in Czechoslovakian law to create a national convention in foreign territory to form a government. They had to create it stemming from what exactly was the law before the German invasion. Because that is the law you stand on, not what you create. Because you're there temporarily, you're there provisionally.
Right.
Once they went back and directly tied itself to what was the law back then to form the council, the cabinet, under specifically Czech law, they were recognized. Yeah. So you can't create stuff because you're expressing a so-called will. You have to go back to what it was before the invasion. And that's what you're representing. You're not representing something in the future. Yeah. Then Czechoslovakia was recognized as a provisional government representing the Czech state, not the people. But they were still under German occupation, which led to war crime convictions later for the violations. Yes, I see.
Original follow-up, sorry. They applied their law from their country in their...
Whatever the law was before the invasion began, they got to be in strict compliance to that law. The reason is, the rest of the countries had treaties, right? Those treaties and trade agreements go back to what exactly that system was before the invasion. That's the reason why. It wasn't an arbitrary decision. You got to go back to the law. Before the invasion, you got to go back to the law because the entire system rests on that system.
So in 1893, we were resting on illegal constitution. Which constitution do we go back to?
The Constitution is irrelevant. It's, well, not go back to it. It's what was the Constitution in 1893, January 16th. Remember, that's the state of war.
That was the illegal one.
No. That's when that's the act of war, U.S. troops. The Constitution that existed at that time under Hawaiian law is the 1864 Constitution with its amendment in 1874. The bayonet Constitution is not a constitution purely by the fact that you call it a bayonet Constitution. Because a bayonet is a knife that you put in front of a rifle. But everybody says bayonet Constitution, like it's nothing. Right there is an oxymoron. Because that is illegal. Now, here's an indication of what our kupuna thought at that time. 1891. You know, we always got to go back to what they thought, not what we think today. See, what we think today is off. We have to assume we're wrong. Let's become right. Let's start off with that, we're wrong. That's how I had to start off, because if I act like I knew what I was talking about, I would never get through with this, because I still have my personal prejudices. So this is an indication of the so-called bayonet. There was a history book called Brief History of the Hawaiian People, ordered to be published by the Hawaiian Kingdom Board of Education. W.D. Alexander was the author for that book, 1891. Covers Hawaii history from migration, culture, battles, everything. History book, all the way to 1891, Queen Liliuokalani. Okay? No mention at all of the bayonet constitution. Nothing. It's like it never existed. Because that's illegal. That's like putting in your history book John Gotti in New York talking about the mafia. You don't put that in a history book. That's illegal. Now, if John Gotti became governor, okay, then you put that in your book. Nothing there. Now, in 1899, W.D. Alexander revised the edition, which became the book used in the public schools for 40 years. Yeah, 1899. Guess what he threw in there? The Constitution of 1887, and said it was justified. Then painted an image of Liliuokalani as a tyrant, as Kalakaua, a tyrant. You know, putting in the so-called justification for the provisional government to take over. But in 1899, they're so-called a part of America, they can now put that in the book. And that became the history book. So during the Kingdom era, Yokupuna did not learn anything. If they're in Kau, in classes in 1892, at some public school in Kau, they would not be taught about the so-called bayonet constitution that we keep talking about today. It's out of sight, out of mind. So we have to, remember, go back to how they thought, not how we think today. That's important. Okay. So here's the doctrine of necessity that was actually applied in the 1960s in the British Commonwealth case. Because there was a guy assuming to be a governor general of a British colony in the 1960s, and he was brought up on treason because he just took that position as governor general, right? So they came up with the benchmarks of what constitutes necessity as an excuse for doing something like that without being elected or appointed, right? So this is from a court case, which they also used. This court case was used against that revolutionary in Fiji. I forgot his first name, but Spite. Spite. Okay. Remember, he was the one about 20-something years ago that took over the parliament and captured the prime minister, who was Indian by descent but Fijian, and he was claiming a takeover. Okay, he was put on trial under these same rules, and he lost. He was convicted for treason and imprisoned. But he was also claiming necessity, right? That's why you got to be careful when you're claiming to be a government. Hey, let's not do that. I don't want to put my cousin in sovereignty groups in jeopardy because they don't know what they're talking about. Let's just say they got together, they voted, hey, whatever. And I jokingly say, the Grand Poobah and the Water Buffalo Lodge, because we all know that from the Flintstones. But that's a certain generation, so the younger generation wouldn't know what I'm talking about. They didn't see the Flintstones. They only see SpongeBob. Oh yeah, that's another cartoon. So this is what the doctrine of necessity says today, right? An imperative necessity must arise of the existence of exceptional circumstances not provided for in the Constitution for immediate action to be taken to protect or preserve some vital function of the state. You notice they're referring to the state, separate from the government, right? There must be no other course of action reasonably available. Actions taken must be necessary in the interest of peace, order, and good government. It must not impair the just rights of citizens under the Constitution. Even if they don't even know what their rights are, it cannot impair it.
So do they have to prove that there's no other course of action?
Yeah, and that's why it went through. So the 1960 case, he proved there was no other action, and he was found not guilty. But Spite in Fiji couldn't measure up to these standards. He got convicted. And finally, it must not have the intention of consolidating power, because you don't have that authority to begin with. So your job is basically hold the fort. That's all. Hold the fort and represent the state in this extraordinary situation. That's how it works. And that's what the governments in exile were doing. Okay? Now, here's something really interesting. Those standards of necessity was from 1960s, British Commonwealth. This is what a provisional government is supposed to be, stated by U.S. constitutional scholar Thomas Cooley. He's very well known in America. And he says what a provisional government is. So he says, a provisional government is supposed to be a government de facto for the time being. A government that in some emergency is set up to preserve order, to continue the relations of the people it acts for with foreign nations until there shall be a time and opportunity for the creation of a permanent government. It is not in general supposed to have authority beyond that of a mere temporary nature resulting from some great necessity, and its authority is limited to necessity. Pretty cool, huh? You know what's even more cool? That was written in 1893. Guess who Thomas Cooley is referring to? The provisional government of 1893, saying they're not a provisional government. Because they're trying to give away the country on a treaty of annexation. They can't do that if they're supposed to be temporary. That was his larger article.
Wow.
So here we got exactly what you're supposed to be, and here's the illegal provisional government, which is what you're not supposed to be. So before we did this move back in 1995, can you kind of see that we looked into doing our homework to make sure we do it right? Because we knew about spite, we knew about this, we knew, so we knew this, but how do we do it under Hawaiian law? Right? So, government overthrown, state still exists, right? So this is the key. This is foundational, so we can use international law. If we're not an independent state, we can't use international law. But everybody used to think the overthrow of the government was an overthrow of the state. That's how everybody thought. Right? Actually, you got to separate them. So a provisional government was established in 1995, and people thought we were part of the sovereignty movement back then. I said, no, we're not. It's like, fell upon deaf ears, so should I say just ignorant ears, nobody knew anything. They actually thought we were part of the sovereignty movement. This is operating on sovereignty of the state, not the people. So the purpose of the provisional government as officers de facto is first to expose the prolonged and illegal occupation of the Hawaiian Kingdom. Right? Expose. Second, ensure United States complies. Then provide for effective transition to a permanent government when the occupation ends. That's the mandate. That's all it does, because it's a provisional government. It cannot collect taxes. Yeah? It cannot issue decrees that will get people locked up. We're not in effective control because we're occupying. And that's exactly what the governments in exile were doing in London, taking certain measures to ensure protection of the state and then have the evidence for the prosecution of war crimes after the war ended. Make sense? Okay. So the test on this, we created Perfect Title Company, which is a private company. We're going to prove nobody owns land in Hawaii because 1893, who's the notary? No government. Where's the notary? Who's the registrar for the Bureau of Conveyances? That's an insurgent, 1893. President Cleveland said. So all titles stopped in 1893, and that affected mortgages, because now mortgages are invalid. There's no collateral. What you have is an unsecured promissory note, which is a loan, which insurance pays off the loan that people who borrowed money paid for and got to protect themselves. A lot of pressure on the insurance companies in America. Who do they come after? Us. Instead of telling people, we're telling people don't pay their mortgages. You don't pay a mortgage, you pay a loan secured by a mortgage. See, look it up, dictionary. Remember, what's her name? Barbara Marshall. Remember Action Line? Yeah, finding bad people. She comes to our office after visiting John Jubinsky, counsel for Title Guarantee, which is right on the corner. We're in the corner of Merchant and Richard Street. Title Guarantee is corner of Merchant, Queens and Richards. Right? She comes to the office, says, I would like to have an interview with you. Okay. Puts me on camera. She says, are you telling people don't pay their mortgage? I said, no, you don't pay a mortgage, you pay a loan secured by a mortgage. She went, what? The cameraman was laughing, because I'm watching the camera and he's laughing. And then Barbara Marshall goes, what? So I turn around, pull the dictionary, mortgage, collateral, security instrument. You assign the mortgage to the bank. You're the mortgager, that's the mortgagee. That's not a loan. You're doing that to secure the loan, called a promissory note. You default on the loan, you can foreclose on a property, make up the money owed. Nothing wrong with that. But you have title insurance that the bank requires you to buy for a lender's policy to protect the bank in case the title is invalid and they cannot foreclose. Because they're only going to be passing on bad title. So instead of going for the insurance, they attack us. So I remember at in 97, July, Hawaii Prince Hotel, 500 people show up. I'm on this panel with David Peach, president of Title Guarantee Escrow, Bruce Graham from Ashford and Riston, a law firm, also teaches land titles at the law school at that time. Neil Hulbert from Alston and Hunt, an attorney representing Chicago Title Insurance Company. Myself, Donna Lewis and myself, and moderated by an attorney from Macon Ford. And back then we didn't have PowerPoints, we had slideshows called Fade In, Fade Out. 500 people showed up. We showed why titles are defective. People were shocked. They left the building like you could hear a pin drop. Well, I was there, I saw the whole thing. You know, because remember, I'm in front of you, I can see your reactions, but you cannot see each other's reactions. And I saw everybody's reactions. So when they left, I get approached by Bruce Graham, and he says, you know, Keanu, we need to talk. Okay, what's the problem? He says, you're taking these people on the wrong road. People are going to get hurt. You know, Bruce, I'm not here to argue about people getting hurt or not hurt. We're a title company. We do a title report. It's a package to show that there's a defect in title for title insurance to pay off the loan, to protect the bank. I said, that's all it is. All you got to do is go and refute our title report, not make arguments. Because if you can refute our title report, they can get us on fraud, right? And then he says, I looked at the title report because I sent one to him, my own property in Kulioho, right? We got from the territorial government, illegal. I said, all you got to do then is take the title report I sent you, a copy of perfect title, and go line by line and refute it. Don't argue. And he says, I can't. It is historically and factually correct. So I said, what's the problem? He said, well, America's here, and that's just the way it is. So I said, I didn't know America was involved with title insurance. Because that's what the issue is. 2 weeks later, we get arrested. We get raided by the Honolulu Police Department, white collar crime unit. Get arrested for racketeering, money laundering, tax evasion, and theft. You see when you play this game. All over the news. Joe Moore calling me charlatan. I had to go, it's a charlatan. I look him up, charlatan. Hey, that means crook. What is good? And then they let you drop in the charges. Then they get me on attempted theft of property, a so-called Class B felony, right? And they put me on trial. You can't, real property is not the subject of theft because it doesn't move. Only personal property is subject of theft. Yeah, but no, I get convicted of attempted theft of land. They found dirt in my pockets. The point is, they were trying to smear me. They can't refute you, so smear you. So now everybody keeps saying, oh, he was arrested and convicted for felony. People don't even know what even happened. But that's exactly what they wanted, right? To use, well, how then I got a PhD saying the same thing. And now I serve as an expert witness in court cases that say, oh, it's illegally occupied, I get paid for it. By the state. I'm serious. So you see, the game that is played here is serious, and I don't want people to be involved in the game I play because my job is to expose, and that's part of the exposure.
Henry Trier, Kelly Market College now, and they blame you for people losing their property. And I try to put it to them like any of us. We know the occupier required license. We know in the kingdom we don't require license. Our decision is we want to drive without a license. If we get busted, we get a conscious decision to drive without it. And the people that didn't pay their mortgage.
Okay, wait, Scott. Isaac. Real quick on the terminology. You don't pay a mortgage, you pay a loan secured by a mortgage. Because if you don't have a mortgage, because it's rendered invalid because of what happened, you have title insurance that you purchased to pay off the debt. So actually, you do have contracts to cover this. So when people get hurt, right, that people say, how come they're not going after the judges in making up this stuff? How come they're not going after the sheriffs who are carrying out unlawful orders?
The process would have required them to go back to the title insurance.
Well, the insurance is what they purchase.
So that was already.
Okay, so here's the thing. Anybody here who had or has a mortgage? Raise your hand. Anybody had a mortgage? Okay. Before the bank loans you the money, because you're going to borrow money, okay? Because if you didn't have money, you wouldn't borrow the money, right? Now, when the bank wants to loan you the money, what they want is collateral, so that they can hold on to ensure the repayment of the loan. So you have an asset of a particular value, but you may not have cash, right? So it's an asset. And you can mortgage not just land. I can mortgage this telephone. If this cell phone was valued at $100,000 because it was gold, I can use it as collateral. Hey, you can mortgage personal property too. It's just collateral. That's why you don't pay a mortgage. You pay a loan secured by a mortgage. Now I'm a bank. Before I accept your mortgage, your collateral, I have to make sure you actually own it. So I require you to go to a title company called escrow, which is a third party title guarantee. Their job is to do a title search to make sure that you own the property. You're supposed to take your title search from you today, wherever you got it from, go back to 1845 in the Bureau of Conveyances, because that's where all titles originated. Where all patents and land commission awards stemming from that title, chain of title, right? And they check in the chain of title whether a trustee was able to do what they did, whether a notary was valid, not valid. That's what they check for. And then, if they say the title is valid, the report says it's valid, the bank says we're not going to accept a mortgage until you insure your word. So they require the borrower, if you borrow $200,000, you have to purchase a title insurance policy worth $200,000. It's the debt that you owe to the bank. And that's a one-time premium with that coverage, right? Because if it's found out that title guarantee was not accurate in its title report, the mortgage is invalid. So the bank cannot foreclose, so they have title insurance to use, which the borrower bought. Now, how is this my fault that people losing their homes? You know why? Because people don't even understand how mortgages work. Just like how people don't understand occupation. So again, it's still education, yeah? But you know what? The realtors and the bankers, they know title insurance. It's people going in, borrowing money. All they want to do is keep signing. Whatever I sign, yeah. Turn the key. I want to walk in. They don't even know. They didn't even go back to look at their HUD-1 statement, closing costs. Oh, I bought title insurance. That's the whole point. Because if you can't buy title insurance in escrow, escrow doesn't close, you don't get the loan because of some defect that got to be fixed before it can be insured. So that's how the game is working, and that's what Perfect Title was all about. That's where the Hawaii Prince Hotel explaining. We weren't natives saying, hey, nobody owns land because I'm a native Hawaiian. No, we're saying contract. HUD-1 statement, section 1100. Yeah, right here.
I wish you would make a video so that everyday people can really understand.
I actually have it out, but some people just don't like to read it, like to watch it. Because again, you know, like Manu was saying, no, you can't be right. I'm just joking. No, but you know what? Again, it all speaks to education at so many levels, right? So many levels. And I was thrown into this, not because I chose it, but because it was part of the walk that I chose to walk. I had to be proficient at this stuff to protect myself. You know, I had to. So everything as far as attacks, guess what? It's all war crimes. See, now there's no statute of limitation on that stuff. But my focus is not hurting people, even though they're attacking. My focus is right here. That's my mandate. Expose, comply, provide for effective transition when the occupation ends, treaty of peace. So, coming to a close, I'm going to put it all, wrap it together, because bring it to date, what's going on. So, Permanent Court of Arbitration in the Netherlands. Pretty much everything I shared with you, theoretically, right? It's going to be put to the test. Not just me saying it. It's going to be tested. So the Permanent Court of Arbitration was established in 1899 as a form of dispute resolution for countries so they don't go to war. That's Hague Convention number 1 that created that court. But if they can't resolve their dispute in that court, then they go to war using Hague Convention 2, 3, and 4, which regulates the war. So creating this court did not end warfare. It just provided a means of dispute resolution in a permanent location. That's why it's called the Permanent Court of Arbitration. So the Permanent Court of Arbitration addresses arbitration issues. So the PCA provides administrative support in international arbitrations involving combinations of states, state entities, international organizations, and private parties. Private parties can only go to the court if a state is involved as one of the parties. Private parties themselves cannot go on their own. Okay? They can go to their own system within their state called arbitration. But they can't, it's not international. So international is a law between nations. That's what international arbitration means.
That's how the Larson case.
That's what we're going to get to. Yeah, that's where the test is going to come. See, proof is in the pudding, yeah, not in the recipe. Because I could tell you a good story. Then that pudding tastes like mud. Let's see if it tastes like mud. Right? So the Permanent Court of Arbitration is an intergovernmental organization that creates ad hoc tribunals. The Permanent Court of Arbitration does not have standing courts where you come in, like the circuit court or the district court. What they have is they form ad hoc tribunals determined by the dispute. So if you have a dispute on boundaries, then the Permanent Court of Arbitration will assist in selecting arbitrators who have boundary dispute background. Because arbitrators, you want experts in, right? That's what arbitration is really so good. Okay? If you have issues of occupation or war, you have arbitrators that have that background to be formed. So they create ad hoc tribunals, but before they can create the tribunal to resolve the dispute, they have to ensure that a state is involved, right? A state under international law, which is independent, right? So, the PCA has institutional jurisdiction for the following disputes. First, between two or more states. Okay? So here's from the case repository at the Permanent Court of Arbitration. Republic of Ecuador versus the United States of America. The dispute is a treaty interpretation. You notice they identified the claimant, which is a plaintiff, respondent as a defendant, Ecuador state, United States of America state. Then they can move to create the tribunal. Right? So it's institutional jurisdiction, not subject matter jurisdiction of the tribunal on a particular dispute. This is institutional. Second is between a state and an international organization. So from the Permanent Court, Peru versus United Nations, Office of Project Services. They identify Peru as a state, the UN as an international organization. Then they create the tribunal. Then we have between a state and a private entity. And this is the Larson case. You notice right here, claimant, private entity, Lance Larson, Hawaiian Kingdom state. They verified it. That's huge. That's like HSTA and the NEA. But nobody really understood it because when I came back from The Hague, I tried to explain it. Everybody's telling me, no, that's not what it was. Like, wow, you was there.
Huger than HSTA.
What is that?
Huger than HSTA.
Exactly.
Yeah, right.
Oh, yeah. But you know, when I came home, though, everybody's trying to tell me, no, that's not what happened. Really? Last time I checked, I was there. But all these sovereignty groups, you know, it feel like a threat, I guess, because, you know, that's not them. So, this was a dispute, just as it says, between Lance Paul Larson and the Hawaiian Kingdom, whereby Lance Larson, a Hawaiian subject, alleges that the government of the Hawaiian Kingdom is in continual violation of these treaties, and therefore is negligent for allowing the unlawful imposition of American laws over him, which led to his incarceration and his unfair trial. That's what the whole case was about. But inherent in that dispute, you gotta have a government, and you gotta have a Hawaiian subject. And then you need a Hawaiian kingdom that the Hawaiian government and the Hawaiian subject is in. So when the case first started, we were the defendants. We were defendants in this. And I was actually the lead agent. So there's me right there. Okay. And it's all from the Permanent Court of Arbitration. This is not manufactured fake news. Okay. So as the agent of the Hawaiian Kingdom, we're the defendants. Ninia Parks, representing Lance, is the counsel coming after the Hawaiian government for negligence. They want to sue us for reparations. Because it was a real issue. Lance was in prison. 30 days, 7 days solitary confinement for following Hawaiian Kingdom law. Right? Unfair trial. Now, before they can create this tribunal, these are the arbitrators, Gavin Griffith, Professor Greenwood, Professor Crawford. They had to ensure that the Hawaiian Kingdom exists as a state. And when the case first was filed in November of 1999, the Permanent Court of Arbitration Secretariat, the registry, the Secretary General, was doing their due diligence before the tribunal could be created on determining whether or not the Hawaiian Kingdom exists as a state. Because if it didn't, and Hawaii is a state of Hawaii, they wouldn't be able to take the case because that's a violation of U.S. sovereignty. Because only the U.S. can go into the court, right? So that's what they're faced with. So from November until February, they're doing their due diligence. I called the court on a procedural matter, and the Secretary General was asked to come on the line because he said he wanted to speak to me. And he says, Mr. Saib, and I remember this conversation very vivid. He says that they cannot find any evidence that the Hawaiian Kingdom doesn't exist. That's how he worded it. Because Lance Larson's attorney provided the Dutch-Hawaiian Treaty, right, the Netherlands, all the treaties, a joint resolution, they didn't annex anything, there's no treaty of annexation, there's no treaty of peace, nothing. And he also acknowledged that the Dutch treaty wasn't canceled. Now he's talking to me representing the Hawaiian government, not Ninia Parks, the attorney for the private entity, Lance Larson. So then he says, in order to maintain the integrity of this case, that's how he said it, to maintain the integrity of this case, because they're walking on pins and needles at that time. He would highly recommend that the Hawaiian government, with the consent of Lance Larson's attorney, travel to Washington to provide a formal invitation for the United States to join in the arbitration. We're going to call the bluff. Because if there's any entity that can dispute the existence of the Hawaiian Kingdom as a state, it would be the United States of America. Because we're supposedly a 50th state. The Permanent Court of Arbitration could find no evidence. All they find is American laws passed by Congress, which is the subject matter of the dispute, which we are allegedly allowing to be imposed. Right? So went to Washington, had a meeting with the State Department, March 3rd. That guy was shocked. He didn't realize that the case was actually accepted by the Permanent Court of Arbitration. We didn't ask them. Ninia Parks just followed it. It's called procedures. Just follow the rules. That's what we did. Or they did. And I told them, I'm going to reduce this conversation in writing, that the United States has been given an opportunity to join in, as requested by the Secretary General. Right after that meeting, put it in writing, email it to the registry. Formal notice was given. You guys have that record. The next week, I get a call from the Deputy Secretary General, Phyllis Hamilton, who says that the American Embassy in The Hague has notified the court that they respectfully deny the invitation to come in, but ask permission from the Hawaiian government and Lance Larson's counsel to have access to all records and pleadings. Because normally arbitration is private. We're making it public. So the Deputy Secretary General is asking whether or not the government will concur, and then she's going to call Lance Larson's attorney to see if he would concur, which we both did. It was in April, this is now March, it was in April, mid-April, that the tribunal was formed. That means the tribunal was not formed in November when the case started. It was formed in April after this process has been vetted, procedurally. And then pleadings were scheduled to be submitted, memorials, counter memorials. Then a procedural order came out, July, procedure order number 3, saying that the tribunal is being asked to first determine whether or not Lance Larson's rights have been violated by the United States. Remember the trial and his confinement. Second, the tribunal is asked to adjudge that the Hawaiian government is liable for those violations. So what naturally came up was what is called the indispensable third-party rule. Under international law, tribunals cannot rule on the conduct of states that are not parties to the proceedings. They're indispensable. They don't have subpoena powers where they require the state to come in. Remember, they're sovereign states, right? So they set up a hearing for December 7th, 8th, and 11th, Thursday, Friday, and Monday, to address these issues. And you folks may have seen the video of that online, right? Okay. So, everything I just said, which is how it was procedurally, this is the American Journal of International Law that spoke of and wrote about international cases. This one being the Larson case in The Hague. Every year, the American Journal of International Law addresses cases that have been heard at the ICJ, PCA, Law of Sea, International Criminal Court, all international cases. So this is what the American Journal of International Law said in 2001. All them now, and these are experts. It says at the center of the PCA proceedings was that the Hawaiian Kingdom continues to exist and that the Hawaiian Council of Regency, representing the Hawaiian Kingdom, is legally responsible under international law for the protection of Hawaiian subjects, including the claimant. In other words, the Hawaiian Kingdom was legally obligated to protect Larson from the United States' unlawful imposition over him of its municipal laws through its political subdivision, the state of Hawaii. As a result of this responsibility, Larson submitted that the Hawaiian Council of Regency should be liable for any international law violations that the United States had committed against him. That is exactly what the case was about. But everybody back home, they was making stuff up. They just clearly making things up. Yeah. And I'm sitting there going, oh, that's not what happened. And I try to explain, no. Okay, Hawaii, take it easy. I guess you know everything. What school you went? Well, you just graduated from high school? Oh, well, you answered my question already. So there's me over there making the argument with the beard, you know. I was actually there, arguing the case, right? So I really know it quite well. So it's for real. It's not fake news. And what they say in the arbitral award, a perusal of the material discloses that in the 19th century, the Hawaiian Kingdom existed as an independent state. Remember that statement? That is locked into international law. That's a decision. So that means the Permanent Court of Arbitration is saying that the United States in the 19th century said only Hawaiian law applies in Hawaii. And what we're dealing with today, we're still dealing with the unlawful imposition of American laws. So that's the birth of when only Hawaiian law applies internationally. Right? And then it goes on to the indispensable third party. So how I explained it to you folks, let's see how they explained it. And I think you folks get it. It follows that the tribunal cannot determine whether the defendant, Hawaiian Kingdom, has failed to discharge its obligations toward the claimant, Lance Larson, without ruling on the legality of the acts of the United States. Yet that is precisely what the monetary gold, that's the first indispensable third-party cases. Yet it is precisely what the monetary gold principle precludes or prevents the tribunal from doing. And it's the second case. There's only two indispensable third-party cases. Monetary gold, East Timor. As the International Court explained in the East Timor case, the court could not rule on the lawfulness of the conduct of a state, called the Hawaiian Kingdom, when its judgment would imply an evaluation of the lawfulness of the conduct of another state, the United States, which is not a party to the case. That's the indispensable third-party rule. That has nothing to do with whether or not the Hawaiian Kingdom exists. We're there because it exists. We're there because we are the provisional government, trying to defend ourselves from a Hawaiian subject that is claimed to be for reparations. Make sense?
Yes.
Very simple, I think. Don't have all of the parties claims, they can't review all of the evidence, they can't come to a determination without all of the evidence.
Because they can't rule that the United States violated Lance Larson's rights without them being there.
Right.
But if the United States is not there, then they can't get to the second stage of holding the Hawaiian Kingdom liable for those violations. So that's why it's the indispensable third party rule. But they said, but you can go another route where the indispensable third party rule may not apply, which we found out it doesn't. Fact finding, paragraph 13. At one stage of the proceedings, the question was raised whether some of the issues which the parties wish to present might not be dealt with by way of fact finding, in addition to its role as a facilitator of international arbitration. Again, whenever you see the word international, it's a law between states. Existing states. The Permanent Court of Arbitration has various procedures for fact-finding, both as between states and otherwise, called a state and a private entity. A request that the tribunal should reconstitute itself as a fact-finding commission of inquiry would have raised a number of issues. A new compromise, which is French, or agreement would have been required and blah, blah, blah. Okay? So they're basically saying you can, but what's most important, they also say here, the tribunal notes that interstate fact-finding commissions so far held under the Permanent Court of Arbitration, which up to date have only been 5. We're going to be the 6th. Have not confined themselves to pure questions of fact, but have gone on expressly or by clear implication to deal with issues of responsibility for those facts. Who's responsible for putting Lance Larson in prison? Is it Judge Sanzashudi? Is it the Sheriff's Department that locked him up? Is it the governor? Is it the mayor? Hey, who? The Permanent Court of Arbitration's fact-finding commissions of inquiry are very similar to grand juries. They look at the facts, assign responsibility, probable cause, but it's up to another court to prosecute. That's what these fact-finding commissions of inquiry are under the Permanent Court of Arbitration. That's what they meant, that they deal with issues of responsibility. Yeah, because I looked at former cases that they held up there. It's not like a typical fact-finding under the UN Human Rights Council. They send a group out to Syria, they gather facts, but they give those facts to the UN Human Rights Council to determine liability, and that's when it gets political. Actually, under the Permanent Court of Arbitration, it's the total package. And the first one was, I believe, well, I'm going to cover that. So I'll get to that. But, so, here we are from 2001. It was decided, when we got back from The Hague, we have to deal with brainwashing. Everybody's brainwashed, denationalized. That was a given. We were approached by an ambassador from Rwanda in The Hague. We had a meeting in Brussels, Belgium. He was ready to basically work with the Hawaiian government, provisional government, to report to the United Nations General Assembly the prolonged occupation of Hawaii. But we have to respectfully deny that because we have to go home and begin re-education. Because we're not going to get them caught up in this confusion, right? So that's when it was decided. I went to University of Hawaii, 2001, January, got back from The Hague in December of 2000. Entered University of Hawaii Poli-Sci Department, get my master's degree, specializing in international relations. I'm going to know these terms. I'm going to learn all this stuff. I want to get my PhD. That's what I'm going to start addressing the brainwashing. And that's what we've been doing, exposure, right? You folks have seen me. Every time you see me giving presentations, right? It's part of the exposure. We got to do that. Ensure compliance. Take steps. Because that's our mandate. And then we knew we're going to go fact-finding. South China Sea case. The building islands in the middle of the South China Sea. Arbitration award comes out. It's talked about at UH on this list server. And I'm with these other PhDs, Hawaiian Society of Law and Politics, and it pops up, and Lawrence Guncher made a point on the arbitral award. And I went, wait, let me read that. Went to the arbitral award, and it made reference to an indispensable third party rule. But it made reference to a previous award called an award on jurisdiction, which was before the final award, which was issued this past summer. Okay? And I'm like, wait a minute. I know there's only 2 indispensable third party cases. Monetary Gold, East Timor. Right? I'm like, in my mind I'm thinking, what if they cite the Larson case? I mean, I didn't know. I just thought. And then I went, and I'm like, wow. So here is the South China Sea case. Philippine state, China state, just like the Hawaiian Kingdom state, right? Here's the arbitral award on jurisdiction. The present situation is different from the few cases in which an international court or tribunal has declined to proceed due to the absence of an indispensable third party, namely Monetary Gold, East Timor before the International Court of Justice, and Larson versus Hawaiian Kingdom. Wow. We're now the 3rd precedent case in international law. Prior to that was just Monetary Gold, East Timor, because that's what Ninian Parks had to deal with. It goes on to say, in all of those cases, the rights of third states, respectively Albania, Indonesia, and the United States, would not only have been affected by a decision in the case, but would have formed the very subject matter of the decision. Additionally, in those cases, the lawfulness of activities by third states was in question, whereas here, none of the Philippines' claims entail allegations of unlawful conduct by Vietnam or other third states which border the South China Sea. Larson versus Hawaiian Kingdom is now Roe versus Wade. Oh yeah. When I read that in the arbitral order, my smile was from ear to ear. Like, wow. But for me, Lance Larson is still a victim. He is. And we're gonna now take it to fact finding. I think the time is right. So, Permanent Court of Arbitration, they also deal with fact-finding commissions of inquiry. Commissions of inquiry under the auspices of the Permanent Court of Arbitration serve in a similar capacity as grand juries. Commissions of inquiry not only review sets of facts, but also assign responsibility for those facts, whether civil or criminal. To date, there have been only 5 international commissions of inquiry since the Permanent Court of Arbitration was established. The first in 1905 between Great Britain and Russia, and the last in 1962 between Great Britain and Denmark. We moved to form the Fact-Finding Commission of Inquiry. So it would be 3 commissioners. Now, let me back up. Let me go back to the arbitral award. Okay. Paragraph 13.2, that's important. A request that the tribunal should reconstitute itself as a fact-finding commission of inquiry would have raised a few issues, namely agreement, right? Which means they were saying we can be reconstituted. We cannot go this way, but we can go this way, right? Well, did you know that 2 of the arbitrators today, no, 2 of the arbitrators back then, I'm sorry, are now judges on the International Court of Justice. Professor Judge Greenwood and Judge Crawford. What we found out was that sitting judges can sit as commissioners under the Permanent Court of Arbitration.
They can?
They can.
Okay.
We found cases that they serve as arbitrators, even though they're still sitting as judges across the hall at the ICJ. Because remember, arbitrators are people that have expertise. Judge Greenwood's expertise, laws of war and occupation. That's why he was selected. Judge Crawford, his expertise, state responsibility for international wrongful acts. That's why he was president. And Gavin Griffith was selected because indispensable third party. That was his area. Yes.
The constitution would include those same individuals from the last party.
Oh, no, so Lance and I are looking at this, like, I think we should reconstitute the old arbitral tribunal, which now has 2 ICJ judges, to be the commission of inquiry. So the commission, we're gonna move on that. I'm actually heading off to London next week. The commission will determine first, what is the function and role of the government of the Hawaiian Kingdom in accordance with the basic norm and framework of international humanitarian law? Now that question is important for you to understand the law of occupation. Remember, the law of occupation recognizes 2 legal orders: occupying state, occupied state, right? What is administering? What are they administering? The laws of the occupied state, which is their independence, right? So before they can look at the provisional government and our role, they need to first of all address what was the role of the United States since 1893, January 16th, under the rules of war, to date, of what they did and didn't do that led us in this predicament that we're in when Lance Larson is alleging we're in violation of his rights. Who's responsible at the highest level? Not just Judge Sancho in this district court that put Lance in prison. Who? So this question, before they can get to answering our role, they need to address through all the facts, all the fact-finding, what is it that they didn't do, which put us in this position, right? And you know, since I got back from The Hague, went to university, I can tell you, there's really no need for them to do fact-finding on their own. We got published law articles, we got dissertations, we got research that has already been done that they can start from, and then move even further. And then ultimately get to what is that role? What is that role? And then once we get there, second, what are the duties and obligations of the government toward Lance Larson? And by extension, all Hawaiian subjects. Yeah? Like all you guys. But can you see, we are the government because that's what this whole case is all about. It's not a matter of trying to form a government. We are the government. And I'm not saying that in a disrespectful way. We are, but we're the provisional government. We can still be held accountable. And our necessity is what dictates our actions. But if it goes beyond the necessity, we can be brought up on treason. And I know it. So now we take all of that back to this. The NEA will publish an article that documents the illegal overthrow of the Hawaiian monarchy, the prolonged illegal occupation of the United States and the Hawaiian Kingdom, and the harmful effects that this occupation has had on the Hawaiian people and resources of the land. Now it's full circle. But if anything now, it's time for us to keep getting educated. Yeah? Don't act like you know what you're talking about, because you're not going to get anywhere. Start off with, I don't know what I'm talking about, and let me learn something. Because I had to do that too. I take the humble pie. I thought I knew something when I did it. And then once you get it, if anything, look at what you can accomplish. Look how fast all of this took place. But we weren't just focusing on the Larson case. When we got back from the Netherlands, we had to focus on re-education. The new battlefield was in academic work. Oh, we're talking about some collisions going on there.
Yeah.
Oh man, some major collisions. But they couldn't refute any of this stuff. But they keep saying it was colonized. They keep blaming the Haole for everything. Put me in a very respectful way. Hey, stop blaming the Haole Hawaiian, because you probably bought Haole. You know, take it easy. Stop blaming the missionaries, because you know, it wasn't the missionaries. It was the faithless sons of missionaries. You know that? Joseph Nabaihi, the Hawaiian Patriotic League, in their petition to President Cleveland in December of 1893, they did not refer to what took place here as a coup d'etat, which is an internal revolution. They said it was a coup de main. Coup de main is an invasion by a foreign force. And that they said that these were a cabal of conspirators who were faithless sons of missionaries. I like that. Faithless sons of missionaries. They weren't missionaries. These guys were judges and attorneys, but you know what they were called? Which we all should say they are? Insurgents. Because President Cleveland concluded that. They're insurgents. Period. Faithless sons of missionaries. Hey, we gotta continue the Patriotic League, right? Hey, it was the Patriotic League that said it. Yes, and with that, mahalo.
Members of the Revival Hawaiian Patriotic League. And in our bylaws, in order to develop our membership over time, we try to maintain an arm's length from any group or individual. And we support your work, and although we can't say we support you as an individual, as a government or whatever it is.
Well, it's your call. The Permanent Court already did it.
Yeah.
So it's not relying on you folks to support.
Yeah.
This is
your future effort. We would like to
what it is.
support your future effort. We're not saying that we support you as a king or whatever.
I'm not a king. Again, terminology. Let's be careful about terminology, because you got to be careful what you say here. Because people here, it's being filmed right now. First of all, I'm not a king. You know when it says Council of Regency? It says what a Council of Regency is. It's the Cabinet Council. But what is a regency? What's the definition of regency?
The one that in place of.
Regency, by definition, like a mortgage, we gotta look it up. Regency is an entity or person that serves in the absence of a monarch. They're not the monarch. The Regency says that, but we don't know the definition of a regency. That's why when Kamehameha III was young, Kahumanu was called regent. When Kalaka was traveling away, Lili was only a princess, but she was called regent, running government. So regency is one who serves in the absence of a monarch, because I gotta stop people saying we're trying to claim to be the monarchy, because that's treason. So let's stop that right here, because we're on film.
Yeah. So we got that documented. So, my question is, how can Hawaiian Patriotic League support the future efforts with the tax planning and things like that? So we're going to continue
That is a good question.
developing our membership, and we'd like to know how we can support the tax planning. I think that's a very significant thing that we can have.
Well, the one thing that you folks all have to realize, everyone here is a Lance Larson. Everybody has gone through what Lance Larson has gone through to some degree. You guys all are. We all are. I am. My experience with perfect title and getting hit, unfair trial, I'm a convicted felon. I'm actually worse than Lance Larson. So you know, everybody's a key on the side now. Right? So when we, so first thing that you folks need to realize is This is not about supporting something. These are proceedings that have nothing to do with you folks, but yet it has everything to do with you folks.
Yep.
You see how I'm saying that, right? But it's about Lance Larson. That's his case. And he got hurt. And now we're getting into what happened before Lance Larson, that first question. There's going to be a lot of things that are going to come to the fore that people are not going to like. And people are going to say, oh, I only had good intention. No, but good intention created a victim or victims. We have to be careful what we're saying.
So, how's your Ukrainian argument coming up?